Good afternoon, everyone, and welcome to our Tuesday session on collections. And we have with us this afternoon Steve Hamilton, who is going to be the speaker and lead you through presentation on collections. Our webinar sponsor this week is CWB, Maxium Financial, who provide financing for strata corporations who are looking for major infrastructure projects or major upgrades and renewals. So many thanks to Maxium Financial. And of course, many thanks to BC Housing for all the outstanding work that they do and their ongoing sponsorship of education programs across the province. Steve's contact information is on the screen. If you have any questions, you're welcome to email him directly. He just loves loads of emails, so it's a great way to start all this off. And just a little reminder to everybody that for privacy, that this webinar is recorded. It does get posted to the CHOA website and to the YouTube channel. If you have any questions as we go through, please submit them through the Q&A, and I'll group and respond them to the end of the presentation, or they may come up directly during the session. But please don't identify your strata plan, your business, or any personal information on this webinar. And then of course we'll try and keep questions until the end if we can, just to manage our time as we go through it. So Steve, without any further delay, it's all over to you to get started, and you can tell any stories about collections you want.
Thanks, Tony, appreciate it. I see my beard has filled in since my last picture there. That was good.
Looks good.
Thank you. So we're going to be talking about collecting money today. There's a lot of material to go through, so we'll be moving fairly quickly, but I think we can manage it. There are really two kinds of collections that we deal with as a strata corporation as we work through the material. One area is dealing with secured claims like strata fees and unpaid special levies, and then we have unsecured amounts that, although the strata corporation has collection tools, they are very different tools. And today we're going to try and understand the different kinds of fees and costs that we collect, understand how we collect them and how they're created, and the tools that are available to us, and the procedures on how the collection process can be taken advantage of. So as I said, there's a number of different kinds of debts that might be collected. There are amounts that are created by the budgets, being the special levies, strata fees, through bylaws, insurance claims, or other orders. And we have, as the slide says, insurance deductibles, judgments, and orders under Section 84, 85 of the Act, which are amounts that can become due and payable as a result of a public work order made against a strata corporation and an owner, and we've got a slide to deal with that at a later time. So there are two different fees and costs that we collect and recover: the secured debts and those fees that may be included on a lien. That's important because lienable amounts allow the strata corporation to create an interest in the land. It gives you a priority charge against most charges that are registered against title, including mortgages. There's only a couple of exceptions, predominantly crown debts, unpaid taxes, and some secured debts like through family maintenance enforcement. Other unsecured debts, which may be bylaw infractions, fines, insurance deductibles, do not allow you to register a charge against the land until you've obtained a judgment from the court. And once you've obtained that judgment, then you do have remedies to forcibly sell the property to recover the outstanding amount, but it's a very different process, not as elegant as recovering unpaid strata fees and special levies, but certainly there are still powerful remedies available to the strata corporation to recover an unsecured claim. So secured debts fall into categories that require the strata to collect the fee, and where the fee or debt owed may be included on a lien. Sections 112 and 118 set out that process. The courts have made it very clear that the strata corporation has to follow the procedures under section 112 through 18 carefully. If you don't, you may find that your lien is unenforceable. You may find that you're unable to recover legal costs. So it's important to understand those provisions and follow them throughout that collection process. Secured debts can include strata fees and special levies, interest if permitted, and it's either going to be an interest that's permitted under the bylaws or potentially under a resolution that's been approved by the Strata Corporation at a general meeting. It can include administrative costs, special levies to pay an insurance deductible, judgments against the Strata Corporation, which isn't particularly common, but if there's a judgment against the Strata Corporation, then each owner owes a proportionate share of that judgment, and it can be registered against title. And as I mentioned before, orders under sections 84 and 85, which are public authority work orders. Those are the secured debts. Unsecured debts can include bylaw and rule fines, user fees, and deductibles, damages claims, costs associated with alteration agreements. For example, if an owner has made a written commitment to deal with any costs or losses associated with alterations that have been approved to by the council, they become responsible for those alteration costs and those costs are recoverable. But it's an unsecured claim. You have to sue and prove the claim and obtain a judgment for that amount. So the types of fees that we collect: strata fees, special levies. The strata fees, of course, are determined through the operating budget annually, and each owner has a unit entitlement obligation towards paying those strata fees. Similarly, special levies may become due. Interest may be payable. Fines and penalties are common for bylaws and rules. And of course, we've got insurance deductibles and damage claims, user fees, the cost of registering a lien, judgments against the Strata Corporation, work orders, and as we talked about before, alteration agreement costs that may become owing. So strata fees are calculated through the budget based on unit entitlements, unless there's been an amending formula through a unanimous vote, which isn't particularly common. Typically, people want to pay based on unit entitlement. Operating budget strata fees and contingency contributions must be calculated separately, and that's typically, you'll see through your property manager's ledgers that those amounts will be calculated separately. It's a really good practice, if possible, as a strata corporation or as a management company that's dealing with statements, to try and separate out at the bottom of the statement those amounts that are accrued and unpaid strata fees or contingency reserve contribution fines or other chargebacks. It's just a convenient way to quickly identify what amounts may be owing by that owner that are lienable or not lienable, because it will inform the Strata Corporation with respect to what remedies may be best to pursue the owner for the unpaid amounts. And amounts, of course, become due and payable in accordance with the bylaws of the Strata Corporation. Special levies, we know, require a 3/4 vote, the exception being insurance deductibles. And then, as I mentioned before, interest can accrue on the special levy through the 3/4 vote resolution, or it may be interest that's permitted by a bylaw. Be very careful about interest when you're calculating the amounts that are placed on your certificate of lien. Strata corporations, property managers have a notorious time getting interest calculations correct, because most of the programs that calculate interest tend to compound things monthly on any outstanding amounts, and you want to make sure that you're compliant with the Act for any lienable charges that only allow you to compound charge interest at 10% per annum. And if you overstate the interest charges on your lien, that lien may very well and probably will be defective. My practice typically is, if I have any doubt about the correctness of the interest accrual, I leave it outside of the certificate of lien. We can always add to the unpaid lien amounts at a later time in the court process or when we're negotiating with the owner. But if you get the interest wrong at the outset, you might find that your certificate of lien is invalid and you'll be going all the way back to the beginning to correct the process. Special levies, funds that are levied for any purpose must be accounted for separately from the annual budget or the contingency reserve fund. And of course, we have the Section 108 requirements You have the 3/4 vote approval. You've got to identify the purpose, the method of the sharing between owners. Typically, it's unit entitlement. You may, of course, have occasions where you're dealing with a section strata corporation, where not everyone is sharing in the special levy. And of course, the amount and the date payable by each strata lot. Avoid using a undefined date on your special levy. For example, due and payable immediately. Most of us know that what it means, but it's probably not compliant with the act. You're better to choose a date, either the date of the meeting or one day after the meeting, so you have a precise date when the amount is due and payable. So the purpose of the levy, for example, here's an example of a roofing replacement. It's a $100,000 levy. The unit entitlement schedule will usually be attached to the resolution showing each owner's amount that's payable and the date of that payment. And interest can accrue again either through the bylaw or approved on the resolution. I'll wiggle my ear, click.
I was going to say, did you want to talk a little bit about additional use of contingency reserve funds, or to deal with things in the event that there's overages, or where
Sure.
they have a number of people who don't pay their special levies?
Yeah, sometimes it's a practice. For example, the council will ask owners to approve the use of the contingency reserve fund to allow for the possibility that owners don't pay on time, and you don't want to run out of cash. So there can be an approved borrowing from the contingency reserve fund in order to offset that lag in the collection of an unpaid special levy. You always have to be mindful that some owners may not pay, and it takes time often to collect those unpaid special levies if you have an owner that is particularly maybe challenging the lawfulness of the special levy, or just doesn't want to pay, or doesn't have the ability to pay. If you have to go through the court process, that can take many, many months and perhaps up to a year if you have to sell the property by force, find a buyer, get the court to approve it. In the meantime, that cash isn't in hand. So having this safety net by allowing the council to use the contingency reserve fund for the purpose of, in this example, the roofing replacement, can be a practical and prudent plan to put in place at the very outset. Is that what you had in mind, Tony? Is that what you
Pretty much. There we go. Well, and in smaller strata corporations, this is a bigger problem, especially if they're doing a major project like roofing and only 16 of you paying roofing and 2 people don't pay their special levies, and then the strata's in a real cash crunch.
Well, and also it becomes potentially more important if the levy is quite significant, where you have $100,000 levy per person, for example. You lose a few owners, and that's quickly several hundred thousands of dollars that aren't available to you for potentially a full year. And as the project reaches conclusion and you don't have $300,000 around, that can become a problem. So the other important thing to keep in mind when you're dealing with substantial special levies in a fairly big project, that even though you want to be potentially sensitive to the financial circumstances of an owner, in times in particular during what we're facing nowadays, councils are often a little more sensitive to an owner's financial circumstances. You don't necessarily have the luxury of a lot of time, so you need to be careful and keep in mind that there can be a lengthy process that you need to work through to recover that many hundreds of thousands of dollars that could be outstanding. And you don't want to be out of money at the end of the project, or your contractor will be unhappy and they'll start registering builders liens, etc. Interest, we've talked about this already. Bylaws are in the resolution. 10% annually, compounded annually, calculated monthly. And here's an example of $5,000, which I think is self-explanatory. You just need to be, like I said, very careful not to start bringing in other non-lienable amounts into that interest calculation, not charging interest over interest, so you're compounding it monthly. And that can be challenging, and you certainly just need to be alive to that problem before you register too large amount on your certificate. Fines and penalties for bylaws and rules. Section 135, you'd better comply with that. If you go on the Civil Resolution Tribunal website, day after day, strata corporations are losing these claims because they are not complying with Section 135. The tribunal seems to be relatively unforgiving when it comes to the compliance with 135. And the Supreme Court of BC and our Court of Appeal has commented that those provisions are very straightforward, and so there's no reason not to comply with them. You need to give notice of the complaint. You need to give the owner an opportunity to respond and have a hearing if requested. If you don't do those two things, you're going to find that you won't be entitled to your fines, and you'll end up in the CRT on the losing side of things after investing a lot of time and effort to get to judgment. Frequency, pretty straightforward. Standard bylaws don't allow for the maximums, but you can amend your bylaws to provide for the maximum. And those amounts are $200 for bylaws, $500 for rentals, $1,000 per day for Airbnb, although I don't know if anyone's doing Airbnb these days. But again, check your bylaws. If you want those fines, then you need to have them expressed in your bylaws and amend the standard bylaws if that's what you have at this point in time. Every 7 days, if it's a continuing contravention, but you need to recognize there's a difference between a continuing contravention and a serial contravention. Here's an example. An owner has loud parties every Sunday and Wednesday. Each of those events are a separate event. Even if it's every Sunday and Wednesday, it's not a continuing contravention. A continuing contravention would be, for example, someone puts an unauthorized satellite dish on their townhouse. You ask to remove it, they don't. You can comply with Section 135 and then begin to say, we're going to fine you every 7 days until that satellite dish is removed. Or the other example with the prohibited pet. But a barking dog every Monday and Wednesday is a serial contravention, not a continuing contravention, although it may be a continuing nuisance. Although we love dogs, Tony, we do love dogs.
We absolutely do, but every Monday and Wednesday, barking is not acceptable.
Insurance deductibles. 158 permits the Strata Corporation to commence an action for an owner who is responsible. This is going to be being changed, or maybe even be enforced now. I don't know if you know yet, Tony, or not, where the legislature has now modified the depth.
Sorry?
Where'd you take me?
Bad things happened.
Modified the definition to essentially require that the Strata Corporation prove that the owner was not just responsible, but committed an act and was negligent. So there's been a legislative change. Is that enforced yet, Tony? Where does that stand?
No, that actually is only a regulatory deferral at this point. It hasn't been defined. Okay. So it's something that's being investigated, and it'll go into public consultation first as to whether this definition should change or not.
Well, that's just proposed at this point in time.
It's just, yeah. It is a prescription, so it may be changed through the regulations.
Yeah, okay. So right now you continue to look at your bylaws, because your bylaws can modify the legal test. If the legal test is responsibility, the burden of proof, or the standard of proof required by the Strata Corporation is much easier. Owner responsibility really will turn on whether the event or the object that resulted in the insurance loss was in the owner's control, originated from the owner's strata lot. If you have to prove something other than responsibility, like negligence, it's more difficult. You have to prove that the owner breached a standard of care, and you'll have to have evidence about what that standard of care is. Again, if you look on the Civil Resolution Tribunal website, there have been many cases where strata corporations have not been successful in these claims because they've had a bylaw that says that the insurance deductible may only be recovered if the owner has committed an act or omission or has been negligent. and they've been unable to prove that the owner had breached that standard of care, and as a result, they were unable to recover the insurance deductible. So look at your bylaws, that will inform you. User fees are permitted. They need to be reasonable and settled in a rule or bylaw. That's regulation 6.9. And of course, if it's a user fee as part of a rule, it does not come into effect until it's ratified by a general meeting, and the slide sets out the section of the act.
That does come to a question that popped up though, that was emailed earlier, with respects to user fees. Once a user fee is ratified by the Strata, so the Strata has a user fee that is charging $25 a month for everybody who's charging their electric vehicles. Any modification of that changes or increases the user fee would itself be considered a new user fee and still has to be ratified at a general meeting.
Yes. Yeah. So
right.
Modification would require further ratification to be an increase in our user fee to be a new user fee.
Yeah, but which is interesting because we're starting to see a trend where strata corporations are just modifying their user fees, but they're not ratifying them at general meetings.
Yeah, it's a requirement. So filing the lien, let's talk about the lien itself and what can you include in the lien. I don't know if the materials include the Form G, but if you look at the Form G, it's structured in a very specific way, and I just want to spend a little bit of time on that because I find that sometimes the lien is overstated, and the case law is very clear about what amounts can be put in the lien. So if you look at the Form G itself, it sets out that the amount owing to the Strata Corporation as of a particular date is blank, and that blank is where you put in the amount of strata fees or special levies, and perhaps your interest charge, but be careful of that. You do not include in that amount any of the costs to register the lien, whether there be disbursements from title searches or anything else, or the administrative charge that the property manager may charge the Strata Corporation, because those amounts, the court has concluded, are recoverable as costs permitted under Section 118 of the Strata Property Act, but they're not recoverable until the court has said so. And the court says so through the court proceeding and not in the face value of the certificate of lien. So be very careful of including those. You're entitled to recover them. They form part of the priority charge, but they just don't go in the face value of the lien. And so keep that in mind. But what are you permitted to recover? The cost of registering the lien is recoverable. Section 118 sets out all those costs. Registering and removal, reasonable legal costs, which nowadays means almost your actual legal fees in most circumstances. So the Strata Corporation should ordinarily not be out of pocket when they're looking to recover strata fees from an owner. Tony, I had a question pop up and then it went away. Are you seeing those? Can you read that to me? Hello, Tony?
Yes, I've got. Yep, I'm monitoring all the questions. Keep going.
Oh, we'll do that later?
Yep.
Okay. So reasonable legal costs, land title and court registration fees, administrative costs, and reasonable disbursements. So it's a very powerful remedy that's available to the Strata Corporation, where in most instances, by the end of this process, the Strata Corporation should have recovered all of its lienable amounts plus all of its costs, including the reasonable legal costs, to recover those amounts from the owner. I think we've covered this. These are amounts and types of fees that we can collect. I think we can move on to the next slide, Tony. We've dealt with work orders. So here's an example. If an owner fails to comply with the work order, then it can be The work order can be issued to the Strata Corporation and the owner. Now here, an example often is hoarders or grow-ops. Those are classic example. Well, here's an example right here of a grow-op that's discovered. A work order is issued by a municipal inspector. And in the event that the Strata Corporation is required to go in and deal with this grow-op in this instance, those amounts can be recovered from the owner and form part of the certificate of lien that can be registered and titled, which is very important for the Strata Corporation because, of course, the minute you have that lienable claim, it becomes a priority charge. You get an interest in the land. So as a Strata Corporation, when you're dealing with owners, if for example, you've got a hoarder or an owner that may be breaching other local government laws, if you can get a public authority like the fire department or the health department or a municipal inspector to issue a work order, even though it's going to place the Strata Corporation within the bullseye, it gives you this powerful remedy against the owner to get the problem dealt with and then recover it as a lienable amount. Alterations agreements, these of course are contractual arrangements between an owner and the Strata Corporation. You're probably all familiar with them, where an owner has requested to do an alteration to common property or limited common property, and the Strata Corporation grants that permission, but asks the owner to become responsible for any costs associated with the repair and maintenance of that alteration, or for any losses that may result as a result of that alteration being done. Can these amounts be recovered against a subsequent owner? Well, because the relationship between the owner and the Strata Corporation is contractual in nature, you need to have the subsequent owner assume the obligations under that agreement. It becomes very difficult to make that owner responsible for those associated costs that are related to the alteration agreement. So often you will want, and really as good practice, the alteration agreement will create an obligation on the existing owner to have the subsequent owner or the buyer enter into an assignment or an assumption agreement with respect to that alteration, a document, so that the new owner becomes responsible. But it's not always easy to control. There is a terrible practice, in my opinion, that exists out there, where alteration agreements are regularly approved at annual general meetings and then registered almost like a bylaw amendment at the land title office. I doubt that puts the Strata Corporation in any better position, but I've seen it done. I wouldn't recommend it, but it happens from time to time.
Well, we've also seen the negative side of that, where the Strata suddenly decides it's time to update their bylaws. So they repeal all their previously filed bylaws, adopt a new set of bylaws, forgetting they now just suddenly repealed all the alteration agreements that they filed.
Or alternatively, you're trying to look for the actual bylaws that exist for that Strata Corporation, and there are 50 historical alteration agreements that are showing up as bylaw amendments, and you have no idea which ones to pull from the land title office to properly understand what bylaws exist or what have been amended. But you still see it happening.
Exactly.
Bylaws, resolutions, liens, the need for real estate Form F, voting eligibility for council, higher penalties, all provide the Strata with enforcement tools. The Form F is really your sort of your last stand when it comes to the owner in collecting unpaid amounts that may be recoverable on the Form F. Remember, they don't allow you to recover everything. They're a valuable tool for fines, penalties, unpaid strata fees, special levies, cost to remedy a contravention of the bylaw, but they're not going to help you with damages, claims, or insurance deductibles. We'll talk about that, I think, in a minute. Also, keep in mind that the Form F doesn't allow you to recover amounts as a matter of law for things that have expired as a result of the Limitation Act. The Limitation Act includes a provision that says if an unpaid obligation has expired due to the limitation period expiring, you're not allowed to exercise any other self-help remedy in order to recover that debt. A Form F is likely a self-help remedy. There's no case authority on this, but it likely is the case. That being said, when you're asked to produce a Form F as a strata corporation, include as much as you can. Let someone ask questions about whether limitation periods have expired. So now we're going to go through some tools that can be effective cudgels to recover unpaid arrears. So voting eligibility and council eligibility, these are good tools. Can deny an owner the opportunity to vote or to be on council. But the key wording you'll see under the Act and what's required under the bylaw is that if the strata corporation is entitled to file a lien against the strata lot. Now you're only entitled to file a lien against a strata lot if you've gone through the procedural steps under section 112, which includes sending out the warning letter that the person is in arrears for lienable amounts, allowing those 20 days to go by to put the strata corporation in a position where they're entitled to file a lien. If that hasn't happened, you're not entitled to file a lien, and you could not deny voting rights or deny someone the opportunity to be to stand for council. So there's what I just talked about. You need your bylaw, and you need to have made the demand about the enforcement process and the period to expire in order to be in that position. What you don't want to do, which I think is on the next slide, well, here's an example. We've got March 2nd, we send out a demand for an unpaid strata fee, not paid within 20 days. That mysterious calculation comes from a combination of things just to make your life difficult. We've got the Strata Property Act that talks about the 2 weeks or 14 days. There's a deeming provision for the mailing, which is 4 days. And plus, then under the Interpretation Act, because of the language of the legislation where it says at least 14 days, you have to add 2 extra days to get you to the 20 days. So once you go through that circular exercise, that's how we get to the 20 days. And that's when the strata would be entitled to register a lien at the land title office. What you don't want to do is you don't want your notice package to say, and this is very common, very, very common, I find, is that the notice package goes out and says, you can't vote if you owe money. And it's misleading and it's wrong. So make sure your notice packages are reflecting the appropriate language that's set in the CHOA slide and not language that is overstating the strata corporation's right to deny votes if it has a proper bylaw. And it's critically important because if you disenfranchise an owner's voting right in a way that was unlawful, it may very well result in the entire voting process being a nullity. So let's be careful about that.
It's surprising how many strata corporations do this and actually prevent people from voting.
Oh, I'm sure you've been at many meetings, and as have I, where that's being done, and you have to intervene and explain that the opportunity to deny that vote is much narrower.
Well, and it's often attempted against things like allegations of bylaw fines and penalties and insurance deductibles and all kinds of other things that are not lienable. And yet people are being asked to vote on things like special levies that have a significant impact on their communities.
Well, and regrettably, it's often used strategically where one group or another starts to determine that excluding votes of a particular group may be advantageous for having the vote either succeed or not succeed. And so that's even more serious because now you not only have the mistake of denying the vote, but you have it for this improper purpose that can potentially result in serious sanctions being granted by the court.
Yeah, opens the door to a CRT complaint all the time.
Absolutely. We've talked about this, about interest, calculated properly, may be included in the lien. As I said, be careful. And it doesn't require notice and/or hearing. It's just an amount that's stated in the bylaws. It's not a fine or a penalty. It's a separate charge that's recoverable under the Act and the bylaws.
It does raise a question, though, that came up earlier that that's good to address here. In that strata corporations might have both a rate of interest and a fine in their bylaws for the late payment of strata fees. You know, can a strata charge both every month?
You can charge both, and what you need to be careful about is that you don't accrue interest on the fine, but you certainly, the fine is a penalty. The interest is a charge on the principal that's allowed under a different section of the Act and the bylaws. So those are separate amounts. The only distinction or the only significance that may arise is that at least the Supreme Court, perhaps the CRT, but it's a little unclear, always has the authority to grant relief from forfeiture when you're dealing with fines. And so sometimes when a judge is exercising his or her discretion, whether or not the amount of fines has amounted to something that's just too much, they can look at also the accrual of interest and take that into account in balancing what isn't fair outcome for the owner. So it can have some significance, but certainly you're allowed to do both. We talked about the Form F, powerful remedy. Include as much as you can. I'm not sure what that last sentence means. Form F, it cannot be included to damages or insurance deductibles unless you have your judgment from the CRT, and you should provide details, expenses claimed on the Form F. Be very careful, be aggressive as a strata corporation in including amounts in your Form F, but in the event that you're hearing from an owner that the amounts are improper and it may frustrate a sale, get some legal advice, see whether or not you can take a firm stand on recovering the amounts that are owing. And of course, there are occasions where an owner has the right to pay money into trust or into court to secure a disputed claim instead of paying it to the strata corporation, but can only do that if legal proceedings have been commenced or an arbitration has been commenced or a CRT proceeding has been commenced. Then they can secure that challenged or disputed debt in trust until the dispute is resolved. So the Form F, ideal for strata fees, levies, interest, fines, user fees, costs, the reasonable cost to remedy the contravention of the bylaw, but not damages claims. Form has to be provided within 1 week, of course. This is all set out in the legislation. It's good for 60 days. There's a fee. There can be rush fees. And the slide's correct. You still have to respond to your statutory obligation, and the rush fee is something that's going to be something that may have been negotiated through the council and the property manager. So financial statements are obviously important. They're going to establish the different types of costs that are owing, when they were applied, the interest that accrues, what's in arrears. I mean, ultimately, as a strata council and perhaps the treasurer or the property manager, organizing and managing your receivables is crucial, because it not only allows you to deal with cash flow in a responsible way, it prevents you from missing limitation periods that can quickly expire. 2 years can go remarkably fast, and you need to take steps to secure those receivables. Keep in mind, for example, with lienable amounts, the registration of a certificate of lien does not preserve your limitation period. The only thing that preserves your limitation period is the commencement of a legal proceeding, either in the Civil Resolution Tribunal, in the Supreme Court if we're dealing with lienable amounts, perhaps in an arbitration. Whatever remedy or whatever procedural tool you're using is the commencement of that lawsuit that's going to preserve your limitation period. So don't stand back and think we've registered a lien and now we're good. That's not going to preserve that limitation period. And I talked about that already, how important it is to manage these receivables. It's still surprising to me that we will get in requests for collections on strata fees and special levies where the strata fees have accrued for more than 2 years. And when that's you're gonna lose those. We do our best to try and recover them, but a knowledgeable owner or the court will probably say you're out of time, and there's really no reason for that to happen. If you're managing your accounts receivable correctly, you should quickly identify that an owner's falling into arrears, and 2 years of arrears is way too long not to be doing anything about it. And you have to be careful also to understand that, for example, with an unpaid special levy, it doesn't help to contact your lawyer a week before the expiration of a limitation period when you haven't registered a lien, because the lawyer is in no better position than the Strata Corporation, and you have to send out the demand. The 20 days has to go by, and by the time you've met those statutory obligations, your limitation period has expired. So you'd better be giving instructions to your lawyer months in advance that you're reaching a pending limitation period, or there'll be little that the lawyer can do to assist you.
So Steve, one of the questions that comes up here is from a Strata Corporation who says that their property manager started an order for sale proceeding, gave instructions to the Strata's lawyer, and turns out there were all kinds of problems with it, including they hadn't processed the Section 135 in bylaw enforcement issues properly. There wasn't a proper calculation. Interest wasn't calculated properly. And the Strata Council's bigger issue is not that the errors were there, because that could be remedied and corrected, but the problem is who actually has the authority to give instruction to actually start an order for sale proceeding. And so, you know, like if you're the lawyer representing the Strata Corporation, you need lawful instructions from someone along with a reliable accounting to be able to do this and undertake this. And shouldn't Strata councils themselves actually be making these decisions and minuting these decisions that they're actually proceeding and instructing to go forward with an order for sale proceeding on the following strata lots for collections?
Yeah, ordinarily, unless there's been some kind of delegation under the management agreement, the authority comes from the Strata Council. It's a Strata Council decision by a majority vote whether to proceed with collection. Now, between property managers and councils, they often will deal with that during council meetings, or put in place a process that they find is convenient, but there's no doubt that the authority generally lies with the Strata Council to give authority to the property manager. And then it's the property manager's, can be the property manager's obligation, if they take on that role, to make sure that the lien is registered correctly. And then it becomes the lawyer's obligation to make sure, before we go down this expensive path of legal process, that there's been a double check to make sure that the accounts were owing and are properly reflected in the lien, and all of the procedural steps have been taken. That's the lawyer's obligation. So there are layers of responsibility here, but the authority comes from, in most cases, the council.
Yeah, exactly. The other part too to that question, or to that comment, is that both property managers and strata councils, this is not exclusive to one or the other, often will just automatically apply a fine for a late payment of strata fee, but it's a bylaw violation. So they still have to go through a 135 notice.
They do, and they have to go through a 135 notice for each month that falls in arrears. It may become a continuing contravention for January, but February is a new month, and so
Right.
is March, and so is April. So these fines are often slapped on as a matter of course, but most of the time there hasn't been compliance with the act and they're unenforceable.
Right, right.
Because it's a lot of work to send out.
It's a lot of administrative
A
work.
lot of work.
Yeah.
I find that the fining on strata fees is probably an ineffective tool because no one wants to go to that administrative burden of sending out the appropriate letters. But
Right.
strata
Which
fees
leads
must be
to the next
paid.
slide.
Pardon me?
Leads to the next slide.
Yes, strata fees must be paid. Council has an obligation to, of course, act in the best interest of the corporation and protect the debt and collect the arrears. I always view that owners that don't pay are borrowing from their neighbors without their neighbors' consent. So I think the council should view it that way. If you're not gonna pay your bills, then someone has to pay them, and it's coming somewhere else from somewhere else. The demand notices has to go out, the filing of liens, imposition of fines, and then in the action for the recovery of debt. Keep in mind that statistically, in these kind of collection proceedings, more than 90% of all of these claims are resolved with the owner or perhaps with the lender prior to a forced sale. A forced sale, the sort of nuclear option on all of this, doesn't happen frequently. It happens, but as a percentage, it's a very low percentage. So I think as a council, you need to make sure you're managing your arrears correctly. Don't be shy to deal with owners in a timely way. You have that duty, but that doesn't mean you can't be flexible. There are ways to be flexible, both at the council level and even when files are with our office. We often will get calls from owners, and in the last several months, it's been more common even, where owners are saying, I just don't have any money. I've lost my job, COVID, all of these things. I mean, people have different circumstances. There's nothing improper with the council allowing the owner a reasonable opportunity to retire that debt. What we do, if we're involved at that level, is we get the owner to enter into a letter agreement for the retirement of the outstanding arrears and a commitment that they're going to continue to pay their ongoing strata fees in a timely way, and a commitment that if they breach this letter agreement, that the strata is at liberty to move forward if it chooses to move forward. And it's important because it holds the owner accountable so that you're not starting all from the beginning again. It documents what promise the owner has made, and it gives the owner a reasonable opportunity to pay down the outstanding obligation. Our practice, and what we usually recommend to strata councils, but there's a lot of flexibility in these things, is to make sure that whatever payment agreement is entered into is that the arrears are dealt with in no later than 6 months. 6 months is a lengthy period of time, but there can be exceptions. It can be less, it can be more, but there's nothing to prevent the council from doing that and still fulfill their duty to act in the best interests of the owners. The sequence, so here's an example. Due date, special levy, February something, 1st, 2015, I don't know what that is. So February 2nd comes along, the strata issues its demand saying you have to pay within 20 days, so we're gonna register a lien. March 1st comes along, the council meets, 3 units are still in arrears, and they instruct the lawyer to have the notice of collection issued to each strata lot and liens filed, and commence the collection proceeding with notice to the lender, and ultimately an application for an order for sale. unless other arrangements are put in place in order to deal with the payment of those arrears. It's a very straightforward process. There shouldn't be any reason why we get this wrong. Things happen, mistakes are made, but on the vast majority of times, we should be getting this right.
So if the strata chooses to file a lien, but they don't go any further because they're trying to be compassionate for owners, and there are substantial changes in 3 or 6 months of the amount owing on the debt, do the liens have to be updated?
Well, if the lien has been registered and the face value, if the amounts, it's a good question. I'm going to answer it this way, but I think there's room for argument. The Act says once the lien has been paid in full, it has to be removed. Very clear. But the law is also clear that the lien acts as a floating charge and accumulates or gobbles up any future accruing amounts. So one argument would be if you put on a face value lien of $500 for months 1 to 5, and through this payment schedule 1 to 5 has been paid, there could be an argument that the lien is extinguished and should be removed. I would be inclined to think that if the owner retires the arrears, but then further amounts continue to accrue, the lien is still good, and I would keep it on. Does that answer your question?
Partly, but what if we've filed a lien? We know that there's some financial difficulties for a number of people right now. We filed the lien to secure the debt to protect the strata, but we've allowed another 3 to 6 months to go by where somebody hasn't paid, and the amount they owe is now 3 or 4 times as much.
Oh, the lien will capture those amounts. So okay. The lien always acts as a floating charge. So once you put on a lien for $100 and people continue not to pay, it may be $5,000, but the court a long time ago, back in the late 90s, concluded that it would make very little sense to require the Strata Corporation to continue to register certificates of lien. It would be administratively expensive, and it didn't make sense within the legislation.
Right.
Yeah. What if the demand or lien includes non-lienable items? You're probably done. The cases have been pretty much consistent that non-lienable amounts in a lien, whether it be $1 or $2, will render the lien a nullity and unenforceable. You may lose your legal costs. I suggest you probably would lose your legal costs, and more likely the entire claim would be dismissed unless you found a very forgiving court. Demands we've talked about. The demand should include everything, of course, but the lien has to be narrow to fit within the language of the Form G.
I was going to say, we'll have some samples of demand letters and statements that we'll post on the website along with this presentation so people can pull them off.
Good. Yeah, and when you settle on a form of demand letter, if the Strata is issuing demands, it's good practice. Pick that form, use it as your template, and ultimately, if you use your template time and time again and it's right, hopefully it's not wrong, you won't repeat your error, but if it's right, you're going to get it right every time. And so you'll have a process in place that won't get you into trouble. The benefits of filing a lien: protects the strata, creates a super priority charge. I mentioned this before. In an unlikely event of a bankruptcy, and this is important and doesn't arise very often, but keep in mind, under the Bankruptcy Act, the minute someone files an assignment into bankruptcy, the legislation says that you're not allowed to take any steps against that bankrupt person, or that person that's filed the assignment into bankruptcy, and that would include the registration of the certificate of lien. Technically, you're obligated to seek leave of the court and the trustee in bankruptcy before you could register your certificate of lien or send out even the demand letters to the person that's filed the assignment. Now, in practice, when there's a bankruptcy, liens go on, we proceed business as usual, and trustees have rarely criticized it. So, but just keep in mind, that's why it's important to get that lien on because someone may be in financial trouble and you're not even aware of it. And of course, it identifies the Strata Corporation as a secured creditor, and that informs the trustee in bankruptcy with respect to how to deal with the Strata Corporation.
And we've had one or two cases where the Crown has been involved, where there's been a proceeds of crime seizure of property. And as long as the lien was filed, the Crown has been very generous with respects to the Strata Corporation. So, you know, the liens really do help to protect everyone.
Well, and putting aside the proceeds of crime, you often have unpaid taxes or other Crown obligations. And we found that in most instances, even though the Strata Corporation under the legislation would be below the Crown in terms of priority, we can usually negotiate with the Crown to allow the Strata Corporation to proceed through the forced sale, and in exchange, the Crown will allow the Strata Corporation to recover all of its unpaid lien amounts plus its legal costs ahead of the Crown. But it only works if there's enough equity. The Crown doesn't like to do the heavy lifting usually. They don't like to do the forced sale. So they're happy for the Strata Corporation to proceed if it makes financial sense. For certain types of receivable, the Limitation Act compels the party to act. You've got that 2-year limitation period. That's going to apply to your strata fees, special levy, damages claims, insurance deductibles, all those kinds of claims. Does not apply to fines and penalties. So don't think that your fines and penalties expire with the Limitation Act. They do not. The court has concluded, based on the language of the Limitation Act, it doesn't fit within that legislative scheme. But for almost everything else that the Strata Corporation will deal with, you're going to have a 2-year limitation period that begins to run on the. It's a discoverability rule when you have enough facts and enough information to conclude as a reasonable person that you had a cause of action against the other party that you're about to sue. Best practice tip: owner 1 month in arrears or missed special levy, issue 20 to demand, owner a registered lien, legal action. That's really where we're left. And of course, as I said before, throughout this process, there's always an opportunity to enter into a reasonable accommodation for an owner that may be in trouble through no fault of their own, may be in trouble that's only temporary, but it shouldn't be the situation where the Strata Corporation, unless the obligation is going to be paid in a very short period of time, you should be going through the process, getting your lien on, and entering into a formal legal agreement with this owner to protect the interests of the other owners. So you can be compassionate, but don't act in a way that puts the rest of your owners in jeopardy. I mentioned section 114 before, where you can pay money into trust if there's a disputed amount. And usually what happens is that the amount will be paid into a lawyer's trust account, sometimes into court, and an agreement or a court order that says once the dispute is resolved, the money will be paid to the successful party. That may be the owner that's challenging the charge, or maybe to the Strata Corporation if they succeed. Form Fs, we've talked about the Form F, how it can be a powerful tool. CRT judgments, this is a tricky part. I'm seeing a lot of judgments coming out of the CRT for unsecured amounts, insurance deductibles, fines, and often they are very small amounts. They can be under $5,000 at times. And the CRT judgment isn't magical, it's just a judgment, and you still have to recover it. CRT doesn't help you recover it. But there are tools available to you, and the question usually is, can you find a tool that's cost effective? The best thing usually is to take that CRT judgment and either register it in provincial court or in Supreme Court, depending on the nature of the order and the size of the claim, and then take that judgment and register it against the strata lot. And it can either sit there on the strata lot, it has to be renewed every 2 years at the land title office, but it can sit there and it will continue to survive until that property has sold, because the limitation period isn't going to expired. The only other remedy you have, well, there are many other remedies, but they may not be effective. Once you have a judgment for any unsecured claim, you can do things like garnishing orders. You can seize assets, seize somebody's car. You can register it against their title and forcibly sell the property through the Court Order Enforcement Act, but it's expensive and clumsy. So you've always got to do this balancing act is, can I recover enough of my $5,000 if I have to hire a lawyer to make it worthwhile? And often the answer is no, so you have to be very careful.
Could easily end up spending more money than what you're recovering.
Yeah, unless you get lucky sometime, if for example you have an owner that you may have particulars of their bank account that you're able to rely on, you may be able to send a garnishing order and recover something from their account, but you may easily send the garnishing order to that account and it's empty, and now you've spent many hundreds of dollars that may get added to the bill, but they're still not collected. Similarly, with the forced sale process in BC Supreme Court, it's a three-part process. You're going to easily spend, up to $10,000 on that. It's very expensive. And so, although you'll recover some of that, you probably would only recover half of it. So, if you're dealing with a $5,000 amount and you spend $10,000 in legal costs and the court awards you $5,000, it's a wash. You're at a zero balance for all that hard work. So unless you've got a judgment that's somewhere around the $10,000 mark, a forced sale process is probably not worthwhile financially.
But this is a pretty realistic approach when we're talking about insurance deductibles of $100,000 and someone has actually done something in their unit resulting in a claim, resulting in a $100,000 loss or greater, and the Strata Corporation, gets a judgment from CRT or the courts that says, yes, this person is responsible for this amount. So, value is a big thing, but it goes to a question that someone's asked that's complicated because it's still being looked at from a legislative perspective, but why can't the Strata Corporation lien for a deductible against an owner when the Strata Corporation finally gets a judgment for it? And the simple answer is because the legislation just doesn't permit it at this point.
These are just choices right now that our government has made, and maybe one day we will be able to, but not right now. But if I had an unpaid deductible of $25,000, or $50,000, or $100,000, you have a judgment from the CRT. To me, it would be worthwhile if there's enough equity in the property, and that's usually fairly easy to determine, to register it against title and start the forced sale proceeding. There are very few defenses to the forced sale proceeding. There are some, but you can evaluate that fairly with some certainty, and so it can often be worthwhile if you're chasing those bigger deductibles. And nowadays we are chasing these bigger deductibles, so they should be looked at carefully. I don't think it's prudent or in the best interest of owners to have a $100,000 judgment for a deductible just sit on someone's title for the next 20 years if they never sell.
No, exactly.
So conclusion, organization, know what you're dealing with for your accounts receivable, make timely decisions. 2 years can come and go in a heartbeat. Don't wait till the last minute. Record your decisions, of course, with your council minutes. Comply with 135. You'll get hammered in the CRT if you don't. It's obvious. Make sure you understand the lien process and only include those amounts that are recoverable under the lien. And of course, ask your friendly neighborhood Strata lawyer for advice when you need it. No, that's it. We have some more questions.
That's super. Just a few more questions because we've covered most of them as we're going along. One of the questions, and this comes up a lot, so the building schedules annual fire inspections to do in-suite inspections and upgrades and stuff, but a number of people don't cooperate and they don't allow access to the units. So the Strata then has to spend money on bylaw enforcement and deal with all those costs. How does the Strata recover those costs? You know, it may be a bylaw enforcement or a bylaw violation issue, but there are additional costs that will be associated with the inspection company. And how does the Strata Corporation recover them in a meaningful way that they can collect them?
Well, I don't know about meaningful, but certainly if it's a bylaw enforcement issue, and let's assume it is, then ultimately they have to prove their claim. They can go to the Civil Resolution Tribunal and say, these are my costs to remedy a contravention of the bylaw. I had all these extra expenses, and here's my evidence, here's my case, and the tribunal will either agree or disagree, but you have to prove your case. Now, arguably, that is those expenses, which were cost to remedy a contravention of the bylaw that required the owner to cooperate with a fire inspection regime, would be recoverable in the Form F. I'd certainly take that position and be aggressive with it. But if you're running up against limitation periods, then you need to go and commence your proceeding and in the CRT and prove your case.
Yeah, no, it's an ongoing challenge. Here's another question that pops up, and we see this in bylaws all the time. I don't know who thought this was a good idea, but it pops up. The Strata has a bylaw that says if a person is in arrears after 90 days, a lien may be filed. But you know, depending on the amount of money owing, like you could have a special levy of $100,000 per unit owing. Why would you be waiting 90 days? You know, the lien isn't going to create a serious complication. It's just going to ensure that the interest of the Strata is protected.
Yeah, I think it's a very bad idea, and usually I see it happening because, it's obviously happening at the ownership level because it's a bylaw. And the idea is it's this idea that we don't want to be overly harsh with owners that are in arrears, but in my view, I think it's better left to the discretion of the Strata Council, who will be in a far better position to evaluate, if they want to, the circumstances of a particular owner and not be shackled with a bylaw. And depending on those circumstances, they can, like I said before, give the owner a reasonable opportunity to pay, relax the payment obligation for a short period of time. But shackling the Strata Council and the bylaw, as you point out, can be a very bad idea and result in unintended consequences.
Well, in filing a lien, by the time you deal with the basic filing charges, maybe a letter from the lawyer advising the amount needs to be collected, etc. It's, you know, $300 to $500, that kind of ballpark. You're not going to file a lien for $100 in arrears. You know, for 30 days in arrears. But again, it comes down to valuing what the cost is. And if somebody's 6 months in arrears, that's a different story than 1 month, you know, late paying Strata fees. And that's what I think Strata councils really need to balance in all of this. Any other closing thoughts for you? Because we're through to our questions and we're through to our time.
I've concluded.
Okay, super. Well, thanks, Steve. Everybody knows how to reach Steve. If you have any additional questions, thanks again to CWB Maxim Financial for their sponsorship. Next week's session is dealing with the Strata Corporation's obligation to maintain and repair and what happens when Stratas don't repair their buildings. And for now, thanks again to everyone for participating today, and stay safe, stay healthy, and we'll look forward to you at our next webinar.
Thanks, Tony.